The 2008 financial crisis exposed how millions of Americans were harmed by predatory lending practices, such as subprime mortgages, payday loans, and overdraft fees. These practices often trapped consumers in cycles of debt, ruined their credit scores, and threatened their financial stability. To prevent such abuses from happening again, Congress passed the Dodd-Frank Act in 2010, which established the Consumer Financial Protection Bureau, or CFPB. The CFPB is a federal regulatory agency whose mission is to protect consumers from harm caused by unfair, deceptive, or abusive practices from financial companies. The CFPB has the authority to supervise and enforce laws for banks, credit unions, lenders, debt collectors, credit reporting agencies, and other financial service providers. The CFPB also educates and empowers consumers on financial topics, such as credit reports, debt collection, mortgages, and credit cards. The CFPB also collects and analyzes data on consumer complaints and financial markets to identify trends and risks. Since its inception, the CFPB has helped millions of consumers get relief from financial harm. The CFPB has recovered over $16 billion in financial relief for consumers as a result of its enforcement actions against companies that violated federal consumer financial laws. The CFPB has also handled over 3.3 million consumer complaints and provided responses to most of them. The CFPB has also issued rules and guidance to protect consumers from junk fees, such as overdraft fees and payday loan fees, that can cost households billions of dollars a year. The CFPB is a consumer watchdog agency that works for American consumers, responsible providers, and the economy as a whole. However, the CFPB is facing a Supreme Court attack that could undermine its independence and effectiveness. In this video, we will explain why the CFPB is important for consumers and how it is being challenged by powerful interests that want to weaken it. The Consumer Financial Protection Bureau, CFPB, is a federal agency that regulates the financial industry and protects consumers from unfair, deceptive, or abusive practices. The CFPB was created by the Dodd-Frank Act of 2010 in response to the financial crisis and the Great Recession. One of the most controversial aspects of the CFPB is its funding structure. Unlike most federal agencies, which rely on annual appropriations from Congress, the CFPB receives its funding directly from the Federal Reserve System. The CFPB director has the authority to request up to 12% of the Federal Reserve's annual budget, without any oversight or approval from Congress. This funding structure is challenged by trade groups representing the payday loan industry, who argue that it violates the Constitution's Appropriations Clause, which gives Congress the power of the purse. The payday lenders claim that the CFPB's funding mechanism deprives Congress of its constitutional role in controlling federal spending and creates an unaccountable and powerful agency that can impose burdensome regulations on their industry. The legal battle over the CFPB's funding structure has reached the U.S. Supreme Court, which agreed to hear an appeal of a lower court decision that ruled in favor of the payday lenders. The lower court, the Fifth Circuit Court of Appeals, held that the CFPB's funding structure was unconstitutional because it crossed the line between a constitutionally and unconstitutionally funded agency. The Fifth Circuit also threw out a CFPB regulation that governed payday lending. However, another lower court, the Second Circuit Court of Appeals, reached a different conclusion and upheld the CFPB's funding structure as constitutional. The Second Circuit found that the CFPB's funding structure was authorized by Congress and bound by specific statutory provisions, and that Congress provided an intelligible principle to guide the CFPB in setting its budget. The Supreme Court's decision on this case will have significant implications for the future of the CFPB and its ability to protect consumers from financial harm. If the Supreme Court agrees with the Fifth Circuit and strikes down the CFPB's funding structure, it could mean that the CFPB would have to rely on congressional appropriations for its funding, which could make it more vulnerable to political influence and lobbying pressure from the financial industry. If the Supreme Court sides with the Second Circuit and upholds the CFPB's funding structure, it could mean that the CFPB would continue to operate independently and autonomously from Congress and pursue its mission of consumer protection. The CFPB's funding structure is one of the main reasons why it is under attack by the Supreme Court. Unlike most federal agencies, the CFPB does not depend on Congress for its budget. Instead, it gets its money from the Federal Reserve, which collects fees from banks and other financial institutions. This gives the CFPB more independence and autonomy to pursue its mission of protecting consumers from unfair and abusive practices in the financial sector. The Biden administration and Democratic lawmakers have defended this funding arrangement as essential for the CFPB's effectiveness and stability. They argue that it allows the agency to plan ahead and respond quickly to emerging issues, without being subject to political interference or pressure from powerful interests. They also point out that the CFPB is not the only federal agency that is funded by fees rather than appropriations. For example, the Federal Deposit Insurance Corporation, FDIC, the Office of the Comptroller of the Currency, OCC, and the Federal Housing Finance Agency, FHFA, are all funded by fees from the entities they regulate. The supporters of the CFPB's funding structure also claim that it follows a long-standing precedent of creating independent agencies with a single director who can only be removed for cause. They cite examples such as the Social Security Administration, SSA, the Federal Trade Commission, FTC, and the Consumer Product Safety Commission, CPSC. They contend that these agencies have been able to perform their functions without compromising their accountability or transparency to Congress and the public.